Hello and welcome to the Muckle LLP webinar on ACAS Early Conciliation. I'm Frances Barker. I'm one of the Associate Solicitors in the Employment team at Muckle, and I have with me Siobhan Howard-Palmer.
Hello there.
Today we're going to be presenting on the new process that's going to be introduced with effect from the 6th of April 2014. We hope that this will be a helpful webinar, but recognising also that there's lots of outstanding points that will probably end up being determined in the tribunal. By way of introduction, I'll just explain a little bit about the procedure and the background to it. So early conciliation is a process that's going to be introduced, as I said, from the 6th of April 2014 this year, and it's going to be a mandatory process with effect from the 6th of May 2014. So effectively claimants, to be able to lodge the huge majority of claims in the employment tribunal, will have to go through a conciliation process through ACAS before they're allowed to do that, and we'll go into the detail of how that process works shortly. The rationale, of course, behind this process is to try and reduce the number of tribunal claims that are brought. It's a cost-saving exercise, but also because there are a huge amount of tribunal claims that were being brought unnecessarily and taking up tribunal times and public money. So the rationale behind early conciliation is to try and reduce that. I should say, by way of background, you should bear in mind that last year, in 2013, the employment tribunal fees were introduced for both filing claims but also for going to hearing. So that as well was part of the process of trying to reduce the number of tribunal claims that were being brought unnecessarily, perhaps where settlement was appropriate or indeed where the claimant was bringing a vexatious claim. As a result of the reintroduction of the tribunal fees last year, we have, of course, had a 79% drop in the number of employment tribunal claims since then. And so I think the early conciliation process that's being introduced may indeed reduce it further. Also, the employment tribunal rules of procedure that came into force last year didn't have a huge impact on the tribunal process, but just one point to note is that there was a new Rule 3 which actively encourages the use of ACAS as a conciliatory, independent, neutral service between the parties. Now that wasn't included in the tribunal rules before, and so I think it's a formal recognition of the requirement to use ACAS as a method of trying to settle a dispute between employee and employer rather than using the formal tribunal process. In addition, Rule 53E was introduced, which gives the tribunal the power at a preliminary hearing, which incorporates both the old CMD, case management hearing, but also the old PHR, which is the preliminary hearing. It allows the tribunal to explore at that point the possibility of settlement, which is quite unusual because it's fairly rare in the past that the tribunal has got involved with settlement proceedings at all. But again, it's trying to see if there's a method of resolving a dispute before getting to hearing. There is, of course, another rule under the tribunal rules of procedure that isn't mentioned on this slide, but allows now a ACAS officer to attend the preliminary hearings. Again, that's quite unusual, hasn't happened before. I'm not actually sure how much it will be used in practice because ACAS are already fairly stretched, and so I don't know to what extent they will go along to preliminary hearings to try and resolve issues.
So in terms of actually commencing the process, ACAS are going to publish a form on the 7th of April which will need to be filled in order for the process to be commenced. The way that the form will be dealt with will be either post online or over the telephone, but ACAS are encouraging it mostly to be online, presumably in order for the administrative burden to be taken off them somewhat, although telephone will be necessary in some cases. In terms of the actual form itself, it's quite a basic form. It's just the names of the parties and addresses that are expected to be actually identified in that. There will be no information actually requested about the dispute at the time, and that's because the initial part of this is simply to identify the correct parties and contact them, rather than it to actually be about what the dispute could be. The form can be rejected if it doesn't contain the proper information, and ACAS can contact the claimant to ask for further information. I think the challenge really with this will be in terms of the parties' names and being able to identify the correct party. So with an individual, for example, if they aren't sure who their employer is, which could happen if they work for an agency or through an agency, or they've worked for one employer and they might not have worked for another and they're not quite sure who the correct party is that could be the challenge then for ACAS to be able to say to them, right, well, we need to establish who the correct employer is. And that will have an effect in terms of making sure that that form is filled in correctly. The form is available for both claimants and respondents, and the service can be used by both as well, not unlike the pre-claim conciliation that currently exists. I think in practice it will depend as to whether a respondent will be interested in doing this or not, and as a whole this will only be dealt with really, I think, by claimants, and that will be because, of course, it's a mandatory process.
Just one point to chip in before we move on to the next slide is that there was initially some confusion about what would happen if there was multiple respondents. It's now been confirmed that if there are multiple respondents that the claimant wants to file against, they would need to fill in a separate early conciliation form for each of those respondents, or they need to make it clear on their one form or while speaking to ACAS that there are multiple respondents. So they're not allowed to ignore the fact that there are other companies they would like to file against. So just moving on to the effect that the early conciliation will have on limitation periods, and by that I mean the time limit for a claimant filing their ET1 or claim form. As you'll be aware, a claimant must submit their claim form in ordinary circumstances within 3 months of the effective date of termination, less 1 day, or alternatively, if their complaint is about discrimination, it's 3 months from the date of discrimination, or the act of discrimination, less 1 day. The new legislation that's come in to introduce the early conciliation is intended to effectively stop the clock for the period that the parties are conciliating, so that the claimant doesn't lose out on the limitation periods because of the fact that they have agreed to conciliate with the respondent. The problem with it, though, is that it's caused quite a lot of confusion as to how this will work between lawyers, and also Siobhan's actually attended a few ACAS forums and some confusion at the ACAS forums as well. And I think it's because people are reading the legislation in different ways. So the key points to note is that if the limitation period, the ordinary limitation period of 3 months following the effective date of termination, would run out during the period of conciliation, then once the conciliation has concluded, an additional 1 month will be added on to allow the claimant to file their claim form. Whereas if the period of limitation, so the 3 months, doesn't run out between the date that the claimant filed his EC form and then the date that the conciliation concludes, instead, what is added onto the end of his 3-month period for bringing the claim is just the number of days between the beginning of the conciliation and the end of the conciliation. So, for example, if they've been conciliating for 5 days and then the ACAS officer concludes that settlement will not be reached, 5 days would be added on to the end of their normal limitation period.
And just to say, Francis, as well, that when we've attended the ACAS forums, they actually do seem to be interpreting the legislation slightly differently, and causing some confusion, actually, when I've been there, as they were suggesting at one point that the limitation period could actually be reduced by this process. So, for example, if a claimant was to put in an EC form on day 2 of the limitation period, if they then conciliated for the full month and that was unsuccessful, they would then only have a month moving forward to actually bring a claim in the tribunal, which means, of course, their limitation period is reduced to 2 months, 2 days, which, as you can imagine, in terms of the individuals in the forums that Act 4 claimants were particularly perturbed by. That doesn't seem to be what the legislation actually sets out. However, we do need to be aware of the fact that ACAS have taken a different view to this, and be wary of it. They've also suggested from the flip side of it, that for those who would have the additional month because their limitation period has run out during the conciliation, that they would get that additional month, but also they would get their conciliation time back. So, for example, if you had a claimant who put in an EC form just prior to their 3-month limitation period, they would then have a month's conciliation time and could effectively have a further month then to put in the claim form when receiving the certificate which could equal over 5 months' worth of a limitation period. Now, that is the position that ACAS have advisors on, and we've double-checked that. But from our position in terms of the legislation, that's not actually what the legislation allows. I think it's therefore worth being aware that there is a difference of opinion here in a legal perspective in terms of the lawyers and ACAS and various other experts in the field, that actually this time limit issue really is going to be one. And it will ultimately be up to the tribunals to decide how limitation may work, but it is worth bearing in mind that there is some difference of opinion here. So, to get back to the process, the claimant has put in the EC form, and what ACAS will have is the Early Conciliation Support Officers, or EXOs, who will pick up these forms, look through the forms, and collect and prepare the information. They will be the ones that look at getting the right parties involved, but they will not do any conciliation themselves, as they won't have that detail. Now, the EXO will advise the claimant still to use internal procedures or other means of resolution first. So, for example, if a claimant is still employed at the time that they're contacting ACAS for early conciliation, then there will still be that encouragement to go through, let's say, the grievance procedure or appeal, etc., as ACAS always would. And that will be important because there will still be a measure of the claimant acting reasonably. And if, of course, conciliation is unsuccessful and it actually goes to a tribunal, then the tribunal will still be looking at the actions of the claimant in terms of did they try and go through these processes that they should have gone through. So once the EXO is comfortable with the information that they've got and they feel that they have enough, they will then allocate the complaint to a conciliator, and a letter will be sent out to the claimant. Now, we haven't seen any pro forma in terms of the letter, but I imagine it will basically confirm receipt and that a conciliator has been allocated and who that may be. And then in terms of actually contacting the respondent, the EXO will only contact the respondent if they've got permission from the claimant. Once the complaint is actually allocated to a conciliator, then the ACAS conciliator will attempt to contact the parties. So they'll take a proactive approach to try and see if they can help with settlement. Firstly, they will have to talk to the claimant about whether they consent to actually contact the respondent, which could be the place where early conciliation actually falls down, as the claimant in theory could actually say, no, I don't want you to contact my employer or ex-employer. I'm doing this because I have to and because it's mandatory, and that is that. If they do consent, though, then the ACAS conciliator has the discretion basically to contact the parties to try and see if settlement negotiations are possible. If the ACAS conciliator is unable to contact either party, it can conclude that settlement isn't possible, and in that instance it would then issue a certificate, which will be discussed further on in the webinar. The ACAS conciliator themselves, they have the discretion over the amount of times they try and contact each party, so it would be down to the individual in terms of what they might consider reasonable and also how to contact them. So we're going forward on the basis that the conciliator has been able to contact both parties, and their duty will be to promote settlement, not unlike what their duty currently is in terms of pre-claim conciliation and also conciliation throughout a claim process. So they will be there to try and help, obviously, deal with issues, see if settlement's possible, see if the parties are willing to negotiate. In terms of time periods, I know that Francis has already touched on those, but the conciliation period initially can last up to 1 calendar month. It doesn't mean it has to. If it can be dealt with more quickly, then that's fine. If a conciliation is successful within 10 days, then that's great, but they have basically up to a calendar month to be able to try and resolve this. ACAS will have the discretion to extend the calendar month up to 14 days in order to try and get this resolved if they think that it is close to settling. The parties must consent to the extension, so ACAS will have to discuss with them whether they believe, of course, that we're nearly there in terms of settlement. And then if settlement is possible, as usual, a binding agreement will be drawn up and agreed through ACAS.
So just moving on to the next slide, as we've already mentioned, the claimant will not be able to file their ET1 or claim form until they have an EC certificate, an early conciliation certificate issued to them by the ACAS officer that has been dealing with the matter. An EC certificate will be issued either if the conciliator concludes that settlement is not possible, automatically if the conciliation period comes to an end, which as Siobhan's mentioned is either 1 month or the 1 month plus the 14-day extension, or it might be issued if a settlement is reached, even if a COT3 settlement agreement is entered into. An EC certificate might still be issued if there are certain claims that are outstanding. For example, if someone has managed to settle an unfair dismissal claim via COT3, but they still have an outstanding discrimination claim, then the ACAS officer may then still publish an EC certificate allowing the claimant to proceed with that part of the claim. I should just clarify that on the first point I said that an EC certificate will be issued if the conciliator concludes that settlement is not possible. I have to say that that's not a very high threshold actually, and if they try to contact the claimant and make reasonable attempts to do so but are unable to do so, then they can still issue an EC certificate, and the same applies to when they subsequently try and contact the respondent or the employer. So even if they telephone and get a voicemail a couple of times, that allows the ACAS officer then to produce an EC certificate and allows the claimant to proceed to file their claim form. Which is perhaps slightly frustrating because it doesn't encourage settlement in those circumstances. The Early Conciliation Certificate, EC Certificate, will contain a unique reference number which the claimant must then put on their claim form or ET1 when they file it. And it must be dated and specify the date on which the EC form was received. That's obviously relevant for the limitation periods that we've just been discussing. So where the limitation period has been extended by 1 month, or indeed by a shorter period which just amounts to the days that you were in conciliation, so in my earlier example, the 5 days, that additional extension, the limitation period restarts 1 day after receipt of the EC certificate. So it's relevant to consider how the certificate is sent out, I suppose, and if it's by email, it's the date that it was emailed, and if it's by post, it's the date on which it will be delivered in the ordinary course of the post. I wanted to start by saying on this slide that although there are some exemptions to the early conciliation process, they're actually very limited. In general, the requirement or the mandatory requirement to enter into early conciliation will apply to nearly all of the tribunal claims that we normally deal with: unfair dismissal, discrimination, breach of contract, rights to time off, etc. It's intended that it's very rare that a claimant will be able to file a claim without having at least attempted to go through the process. Essentially, the only claim that doesn't fall within the legislation is where there's no time to allow conciliation. For example, where they're making an application for interim relief, and therefore it's hugely urgent that the claimant proceeds as soon as possible. The other exemptions are set out on this slide here, where the claim is presented on the same form as another claimant who has already complied with conciliation, so this is going to be relevant where there's multiple claimants, for example in equal pay claims. You don't have to go through the process for each individual person. Where the claim appears on the same form as proceedings which do not require early conciliation, as I've just mentioned, that's very rare. Or where the respondent has already contacted ACAS, because of course it doesn't make sense for the claimant to be required then to go through the process again if the respondent had already attempted to do it and it didn't work. I should just mention another point of confusion that has arisen around this. Initially there had been some suggestion that TUPE claims for failure to inform and consult and failure to provide employee liability information would not be covered by the early conciliation process, and the extension to the limitation periods wouldn't apply to them. The same point applied to the claim for failure to be allowed the right to be accompanied, but it seems that it's now being confirmed through sort of rectifying provisions that those claims are also covered by the early conciliation process. So just moving on to the next slide and some of the practical points. I mean, we've already referred to some of these earlier. I think the key one for me is that you need to bear in mind the impact on time limits, the limitation period for bringing claims, and the likely confusion that's going to arise because of this, as Siobhan mentioned earlier. I suspect there will be tribunal claims that have jurisdictional issues to be determined purely on confusion between the parties as to when the time limit ran from and to. So I do think this is going to come up quite frequently in future tribunal matters. The other thing is, from a tactical perspective, I do wonder whether respondents might deliberately not engage in settlement or conciliation in order to see whether claimants are good for the money, given that we've now got tribunal fees. So because the tribunal fee has to be paid at the time that the ET1 claim form has to be filed, will a respondent deliberately not engage in early conciliation through ACAS? And indeed, if that is the case, and then they subsequently go on to tribunal, will they be criticised by the tribunal for having done that and not at least attempting some kind of discussion with the claimant?
And I think on the flip side of that as well, Francis, is it could be the same be said for the claimant. So if the claimant refuses to actually try and conciliate and says, no, don't even contact the respondent, is how tribunals are actually going to respond to that on the other side, and whether that in itself is vexatious conduct on behalf of the individual. Just another point as well in terms of vexatious litigants, the fees were brought in, of course, in July of last year, and part of that was to try and help the tribunal service in terms of those kind of vexatious claims or spurious claims that you know you would try and deal with, and they would be able to do that because they could bring the claim initially for free. And that was, well, part of the reason why the fees were actually introduced. And of course, as Francis has already explained earlier, the actual impact of these fees seems to have been really quite high. But we wait to see as to, and once we've got to a year round, in terms of actually whether that is a fair reflection of the claims that have been reduced and whether that's down to fairness or not. But certainly, the claims have been brought less so because of the fact that there are fees. Now, the early conciliation process is actually a free process. So actually, are we providing another avenue for claimants moving forward for them to be able to try and bring a claim vexatiously, and bearing in mind that they might feel they may as well give it a go because they might get something out of an employer who might think, oh, well, goodness me, I'd rather not go to a point where I know I'm going to get a claim, so I will actually think about settling this. And also the fact that they don't actually have to give any information on the dispute form initially, on the dispute initially. So in terms of the actual EXO's job, so that support officer's job, all they need to do is get the actual details. The respondent may or may not get contacted, and then the actual form of the dispute won't need to be considered until a conciliator is already in place, and it may be that claimants can actually take advantage of that.
Just the final point to mention on this slide is in relation to ACAS forms and guidance. We have had published the Early Conciliation Explained leaflet, which is on the ACAS website if you want to have a look through it. Although I have to say it doesn't have a huge amount of detail and is fairly practical points. So I wonder whether further guidance will start to come out as this confusion around limitation periods and how this process is going to work starts to die down. Just moving on to our final slides in relation to the sort of benefits and drawbacks of this whole process. I think the idea behind early conciliation is obviously a positive one in that it should reduce the number of tribunal claims that are being brought unnecessarily and should encourage settlement if parties are interested in it. It highlights to the parties from an early stage the merits of the claim and the defence. Although ACAS is an independent and neutral provider of the services, purely by having discussions between the parties via ACAS, you do start to pick up on what the key merits of the claim are or what the key merits of the defence are, and that will be highlighted from a very early stage. And also, it could avoid costly legal fees if settlement is reached via ACAS, which is a free service. There are, of course, various drawbacks to the new process. The main one that we've already discussed is that there's a huge amount of confusion around the limitation periods and the time limits, and also which claims are included or not included in the process. The other thing I just wanted to briefly mention is the delay to the tribunal process generally, because if you think about the problems that have arisen since the introduction of the tribunal fees last year, is that the respondent isn't notified of a claim having been filed against it until not only has the ET1 form being filed, but also if that claimant has not been able to pay their own fees but has gone through a remission system, so has applied for their fees to be paid for them, then that respondent doesn't get notified until the end of that process, i.e. when the fee is then paid, and that can add on quite a significant amount of time in addition to now the early conciliation process. So we used to be able to say that a respondent could sort of wipe their brow if they'd not heard anything about a difficult employee 3 months after the end of their employment, but I don't think it's as simple as that anymore. There's so many different practical and legal aspects to this whole process that means that a respondent's going to have to wait a lot longer before they can comfortably say an ex-employee is not going to raise a claim.
And also not forgetting as well, Francis, that because there's no requirement for that individual to actually consent to an employer being contacted through ACAS, is that actually you may be none the wiser as an employer as to whether they're going to bring a claim or not. They could simply contact ACAS because they know they have to, say, actually, no, I don't want you to tell my employer I've contacted you, and there goes the certificate, and okay, there's only a slight extension in time in terms of that, but there will potentially be an extension in time, and you will still be sitting waiting to find out if you're getting a claim or not.
Yes, exactly. Just a couple of the other drawbacks on this slide. We've already mentioned that, of course, the process is voluntary, and so it's quite easy for either party to pull out. As Siobhan's just mentioned, the claimant might not be interested, and then there's no requirement to contact the respondent at all, even though the respondent might actually have a very good offer to put forward. But if the claimant wants their day in court, they see red, then the respondent might not even have that opportunity. Of course, they can still contact ACAS at a later date, but it will be following receipt of the claim form.
Yeah, and I think in terms of that, Francis, actually, the ACAS, of course, will continue to conciliate throughout, and their hope is that, so if a claim is brought, and it's hoped that it will be the same conciliator. So if you go through early conciliation, that's unsuccessful, a claim is brought, but then in the tribunal, ACAS will still have the same model that they always would do with a tribunal claim, and the conciliator is hoped to be the same. But of course, this will depend on how ACAS will handle this from the perspective of whether this is actually going to increase their workload significantly or not. So there's also that to take into account as well.
Thank you very much for listening to our webinar today. I hope you found it useful, and I'm sorry that there is quite a lot of confusion around the issues that we're talking about. One point just to mention is that we will be doing a Q&A, question and answer session for this and the other changes that are coming into effect in April 2014 on the 28th of April. So if anyone's got any questions around this, please just keep an eye on our website, which is listed on the slide in front of you, and log into the Q&A session and you can challenge us on these points. Thank you very much, and goodbye.
Thank you. Take care.